So, good afternoon, class. Welcome back to our discussions on the different circumstances affecting criminal liability. So, we've already finished discussing justifying circumstances, exempting circumstances. So, I hope that you will not forget the concepts under those circumstances because as we continue discussing in mitigating circumstances, we will likewise continue to discuss some aspects of justifying and mitigating circumstances. So later, we will understand better why these three are actually interconnected. The justifying circumstances and the exempting circumstances in relation to what? Mitigating circumstances. So we are now moving forward to our discussion on the next article of the revised penal code. So I will be sharing now my presentation. So as a review, okay, so that you will also not forget. So let's first discuss the different justifying and exempting circumstances, okay, so that you will never ever forget these concepts because again we will continue to discuss them as we go along with the different circumstances affecting criminal liability. So article 11, justifying circumstances, the following do not incur criminal liability: anyone who acts in defense of this person or right, provided the following circumstances concur. First, there be unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. And third, lack of sufficient provocation on the part of the person defending himself. So take note of this one, class, okay? Because this is a very important concept in self-defense. Because without these requisites, then there can be no proper self-defense. Okay, if the three are not present, then there is no self-defense to say. Okay, or to speak of. Anyone who acts in, then let's go to the paragraph 2. Anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate natural or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite in the case the provocation was given by the person attacked. The person attacked here is the relative, that the one making the defense had no part therein. Okay, so here this is the concept of defense of relatives. Okay, then we move forward to the next defense. What is that? And that is paragraph 3. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisite mentioned in the first circumstance of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. So take note, this one naman, no, this is where defense of strangers come in. So who are strangers? Strangers are those persons not mentioned in Article 2 because those mentioned in Article are considered our relatives. No? So spouse, ascendants, descendants are legitimate natural or adopted brothers or sisters or his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed. So these two, first and second, unlawful aggression, reasonable necessity in the means employed to prevent or repel it, should always be what? Present. No, for defense of relatives, defense of strangers, these two should always be present. So without that, without these two, then there is no defense of relative, there is no defense of stranger. So what happens now if the defense is not considered as defense of relatives or defense of strangers? So we will try to understand that better as we go along and we discuss mitigating circumstances. Okay? So but for now, just make sure that these two requisites are still are also present both for paragraph 2 and paragraph 3 to what? To render a complete self-defense. Now let's go to the fourth justifying circumstance. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. So, take note, class, when we say requisites, it means that these circumstances are actually required. Okay, so if one of the requisites are not present, or one of the requisites is not present, then, or parts of the requisites are not present, then that does not constitute a justifying circumstance. Okay, so this one is the avoidance of an evil or greater injury. Okay, greater evil or greater injury. First, that the evil sought to be avoided actually exists. So there's actually an evil or a greater injury that has to be avoided. Number two, that the injury feared be greater than that to avoid it. So the injury feared or the evil feared should be greater than that done, no? And number three, that there be no other practical and less harmful means of preventing it. So there are no other options to the person who committed not the crime. Otherwise, he will be put in harm's way with a greater evil or greater injury. Number five, any person who acts in the fulfillment of a duty or in the lawful exercise of a right of office. So take note of this again, no? So there are requisites on this one. We've discussed this thoroughly. What are the requisites for the justifying circumstances? Any person who acts in obedience to an order issued by superior for some lawful purpose. So just take note as well that the order should also be lawful. So a superior, for example, a police chief cannot order his men to immediately kill um um an accused, no? So, for example, the police chief orders his subordinates to serve a warrant. He cannot instruct his subordinates that, okay, if the arrestee, no, if the accused does not want to get arrested, you shoot him with a gun. No, that's not also a lawful order, because at the end of the day, take note, we have the right to our life, liberty, and property. So of course, we have the right to be alive, you know. And um even if we committed a crime, no matter how heinous, take note, okay? No matter how heinous, we've discussed this in our law, which prohibits the imposition of the death penalty. Okay, so we already have that law. So even if we committed a grave crime which would warrant the imposition of death penalty, but because currently there is a prohibition on the imposition of death penalty. So even if we committed such a heinous crime, we cannot be killed instantaneously. No? Okay? That is not justified. Okay. So now let's go to exempting circumstances. So we've already finished discussing the justifying circumstances. I'm just doing a review. So this is no longer new to you, because I would assume and would presume that you have watched all the videos that I have prepared for you previously. Okay? So take note of those things, the justifying circumstances. Now we move on to the exempting circumstances. Number one, again, the following do not incur criminal or are exempt from criminal liability. An imbecile or an insane person, unless the latter has acted during lucid interval. So, unless otherwise, the insane person has acted during a lucid interval or committed the crime during lucid interval. But take note, an imbecile person has no lucid intervals. Okay, only an insane person has lucid intervals. So the Proviso here that unless the latter has acted during a lucid interval, it only pertains to insane persons and does not pertain to imbeciles. Okay, so who is an imbecile? An imbecile who is one who, while advanced in age, has a mental development comparable to that of children between 2 and 7 years of age. While insanity exists when there is a complete deprivation of intelligence in committing the crime, that is, the accused is deprived of reason. He acts without the least discernment. So, there is complete deprivation of intelligence. So that's why, as I mentioned, the last time, no, the requisites of a crime are not present. Number one, intent, intelligence, and freedom. So in these two situations, an imbecile and insanity or insane person does not have the freedom because they do not have the intelligence to discern or to understand the repercussions of their actions. That's why they are considered as exempt from criminal liability. Next, um, a person under 9 years of age. But take note, this has already been repealed. The age of criminal responsibility has already been increased to 15 years old. So a person under 15 years of age who commits a crime or an omission is actually exempt from criminal liability. Number three, a person over 15 years of age and under 18. So take note, this has already been repealed unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 18. So, when such minor is adjudged to be criminally irresponsible, the court, in conformity with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with the surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said article. So we will proceed to the article soon. Okay? So, okay. So, fourth, any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. So, elements of this one is that a person is performing a lawful act with due care. He causes an injury to another by mere accident without fault or intention of causing it. No, for example, a police officer was serving a warrant to a criminal. Okay? There was a warrant of arrest. But then the criminal resisted the arrest. Okay, and fired at the police officer. And the police officer had no other choice but to fire back. But by when with the discharge of the gun of the police officer, the bullet hit the wife of the criminal here, or the accused here. So here, the police officer is performing a lawful act. So, the retaliatory firing of the gun is just in response to the firing of the gun of the accused, or the one being served the warrant. Number two, so long as he was performing such act with due care, he causes injury to another by mere accident. So, consequently, the wife was just there, no, in the house with the accused, or the one to be served with the warrant, but then the wife got hit by a bullet, and here the police officer did not actually have any intention of causing the injury to the wife. It was just a mere accident. Okay, number five. What is number five? It's what? The presence of compulsion of irresistible force. So the requisites here is that the compulsion is by means of physical force. So physically what? Physically forced to do something. The person here who committed the act or omission is physically forced, ginpirit hiya, under the compulsion of an irresistible force. That the physical force must be irresistible. Dili niya pwede dirihimuon, because he himself will be put to peril, or will be put in an evil situation. Okay, and that the physical force must come from a third person. So there was this third person exerting irresistible force, no, on the accused, and that he had no other choice. So remember, no, wherein si Bakuli, the case of Bakuli, I've already discussed this with you. He was just forced to bury the bodies of those which were killed by a band in the mountains. So he was also just scared, no, because he himself will be killed if he did not obey the the compulsion coming from the band or the bandits. So he was charged as an accessory of the crime for concealing the body, for burying the body of the crime. But at the end of the day, he was not what held responsible for it because he merely acted under the compulsion of irresistible force. And number six, any person who acts under the impulse of an uncontrollable fear of an equal or greater injury, that the threat which causes the fear is of an evil greater or at least equal to that which he is required to commit. No, that is that it promises an evil of such gravity and imminence that the ordinary man would have succumbed to it. So, ini and those person who were compelled to join, no, rebels, to swear their allegiance to a rebel group because they themselves were actually scared, no, under the compulsion or impulse of an uncontrollable fear, because otherwise if they do not swear allegiance, they themselves might be killed by the rebels. And lastly, any person who fails to perform an act required by law when prevented by some lawful insuperable cause, that the act is required by law to be done, that the person fails to perform such act, that his failure to perform such act was due to some lawful or insuperable cause. So for example, we have the crime of misprision of treason, sedition, and rebellion. Misprision is failure to report to the authority any conspiracy or proposal to commit treason, sedition, and rebellion. But here, um, A confessed to a Filipino priest that there was a plan to overthrow the government. So that would be rebellion. So the priest here, normally on normal conditions, if he was a normal person, he can be held liable if he did not go to the authorities, no, government authorities, to report the rebellion or the plans of rebellion. He could be charged for misprision of rebellion. But then again, under our revised rules of court, no, a priest uh, conducting a confession with a person under a professional capacity, because priesthood is a profession. No, under the law, it's considered as a profession. So if even if A confessed that there was going to be a rebellion, a priest cannot be compelled to share or reveal the information made known to him during a confession uh, while he was under his professional capacity. Okay, so because priests, okay, religious leaders, they have what immunity under the law. So for this specific provision of the law pertaining to confessions, no, their um whatever confession they receive in their professional capacity, they cannot reveal it. Even if they reveal it, that will not be admitted in court because the confession was made under a professional capacity to which the law binds him not to reveal to anyone. Okay? So why did I have to discuss justifying and exempting circumstances? Because going back to my introduction a while ago, justifying and exempting circumstances and mitigating circumstances are interconnected. Okay, so we cannot discuss mitigating circumstances without discussing justifying circumstances. Okay, so mitigating circumstances include, okay, include paragraph 1. those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. So as I mentioned many times, if if the requisites are not complete, for example, the requisites of a valid self-defense, if the three requisites are not present, or if only two of the three requisites are present, so one is missing, one requisite is missing, it is no longer a justifying circumstance, but merely a mitigating circumstance. Okay? So what is mitigating? What is the effect of the mitigating circumstances? It actually, if some mitigating circumstances are present, then it can actually reduce the penalty for the crime, which we will discuss further as we go along the discussions on the several circumstances affecting criminal liability. But for today, let's first determine what are mitigating circumstances. So the first mitigating circumstance is that those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. Okay, so if the requisites, all the requisites necessary to justify or exempt from criminal liability are not present, then even if only one is missing, it becomes a uh, mitigating circumstance, not a justifying circumstance or an exempting circumstance. Number two, that the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 18. So remember my discussion on exempting circumstances. If the offender is above 15 years old but is under 18 years old, he is exempt from criminal liability. But here, if that person who is above 15 years old but below 18 years old has acted with discernment, okay, the exempt it only becomes an exempting circumstance if the person above 15 but below 18 years old did not act with discernment. So that person is exempt from criminal liability. But what if he is above 15 or below 18 but he has acted with discernment? What will happen now? It is no longer an exempting circumstance. The age, no, the circumstance of age is no longer an exempting circumstance, but is merely a mitigating circumstance. Okay, so it does not completely exempt the accused. The accused who is above 15 but below 18, he is not completely exempted from criminal liability. But him being below 18 years old can raise a mitigating circumstance. Okay? Likewise, in this part, as I mentioned earlier, if a person who is over 70 years old commits a crime, then his age becomes a mitigating circumstance. So if there is a mitigating circumstance, the penalty can be reduced. By how much? We will discuss that a little later. Okay? First, let's determine what are these mitigating circumstances. Number three, that the offender had no intention to commit so grave a wrong as that committed. So he did not intend the gravity of the offense or the result of the offense. Okay, I will discuss that further so that we can imagine. Number five, that sufficient provocation or threat on the part of the offended party immediately preceded the act. Okay? So I will discuss that as well. Number five, that the act was committed in the immediate vindication of a grave offense to the one committing the felony against his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, or relatives by affinity within the same degree. Okay? Next, that of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Number seven, that the offender had voluntarily surrendered himself to the person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of evidence for the prosecution. Number eight, that the offender is deaf and dumb, blind, or otherwise suffering from physical defect, which thus restricts his means of action, defense, or communication with his fellow beings. Such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of consciousness of his acts. And finally, any other circumstance of a similar nature and analogous to those above mentioned. Okay, so there are 10 mitigating circumstances under the revised penal code. But today we will be discussing the first 5 mitigating circumstances. We will proceed to discussing the other 5 next meeting. Okay, because I have to give you more examples for the mitigating circumstances on paragraph 6 to 10, because 1 to 5 are very easy to understand, but 6 to 10 becomes more complicated. So I have to explain this thoroughly so that you can understand the concepts. But for today, we will be discussing the first 5 mitigating circumstances. Okay, this is already in what? Article 13 of the revised penal code. So, okay, the first mitigating circumstance is this one, paragraph 1. Okay, those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. So take note, diba, we have number 1 from justifying circumstances, self-defense. Second is defense of relatives, defense of strangers, no, state of necessity, performance of a duty, obedience to an order of a superior, minority over 9 and under 15 years of age, causing injury by mere accident, and uncontrollable fear. So these are the 9 uh, justifying and mitigating circumstances which can be considered as a mitigating circumstance. No, if some of the requisites of these circumstances are not present, instead being considered as justifying or exempting, they are downgraded to mitigating. Why? Because if these are considered as justifying or exempting circumstances, then the person who raises these defenses is actually exempt from criminal liability. But if the requisites are incomplete, no, they are not, for example, the first self-defense, if it's not complete, there are only two requisites present, then it's not a complete self-defense. So it's merely a mitigating circumstance, which means that the person is still liable for the offense. It's just that the penalty may be reduced. In especially if it is proved that there really is a mitigating circumstance. Okay. For example, incomplete self-defense. So we've discussed over and over again what are the requisites for an incomplete self-defense. Oh no, sorry, for a self-defense. No, this one Number one, there should be unlawful aggression on the part of the offended party. So the person who started the aggression is the what? The victim. Number two, reasonable necessity of the means employed. So the means employed should be reasonable and necessary. So for example, in our previous discussions, no, the court will appreciate or will determine the penalty for the crime or the liability of the accused according, for example, to the weapons used, okay, and the number of stab wounds that were actually inflicted on the person, and which parts of the body were actually hit by the weapons, no? So the reasonable necessity of the means employed is that it doesn't mean that there should be 100% equivalence when it comes to the weapons used, okay? It's just that that the weapons used to repel or the means used necessary to repel the aggression is not just mere it's not a mere misappropriation of the weapons. Okay, for example, if you were just slapped on the face, it is not reasonable or necessary to retaliate with a uh gun. Okay. So if the victim who made the unlawful aggression first, for example, 'di ba, ang kicking lang ginbanyakan lahiya hatiil, but then he retaliated by punching the face. The punching of the face was not considered reasonable or necessary because the kicking, just a slight kicking of the foot, no, was just a mere banter or a joke. It wasn't really unlawful aggression on the part of the person, on the part of the victim, okay, or on the part of the person who suffered from the acts, no? And number three, lack of sufficient provocation on the part of the person defending himself. So, what is an incomplete defense? These three, again, are requisites for a valid self-defense. So, if there was no unlawful aggression, no? So, the victim did not start the aggression, but there was a reasonable necessity of the means employed and the lack of sufficient provocation are present, then it is an incomplete defense and it is merely what? A mitigating circumstance and no longer a justifying circumstance. But anyway, no, going back. So for example, there was what? There was unlawful aggression. There was unlawful aggression, but then this one, present, sigunta, ini, unlawful aggression. But the means employed was unnecessary. No, here, for example, here, instead na reasonable and necessary, sorry, or unreasonable, okay. So, if the means employed were unnecessary or unreasonable, then it is no longer a valid self-defense or a complete self-defense, but merely what? A mitigating circumstance. So, if the means employed were unnecessary and unreasonable, not proportionate to the unlawful aggression, then the person who committed the act or omission is still liable for the crime. It's just that such person, what? The penalty for such person will be reduced. But nonetheless, he can still be held liable for the crime and may be given penalties in the form of imprisonment or fine. Okay? So I hope that is clear on your part. Next. So number two, that the offender is under 18 years of age or over 70 years of age. In the case of the minor, he shall be proceeded against in accordance with the provisions of the law. So going back to our discussion, no, absolute exemption is 15 years and below. But then if the person is more than 15 years old but less than 18 years old, if he did not act with discernment, then it is an exempting circumstance. But what will happen now if the person who is above 18 years of age, no, above 15 years of age but below 18 years of age, but he has acted with discernment. So discernment was established here. What will happen now? So again, the age is no longer an exempting circumstance, but only what? A mitigating circumstance. Now, if the person who committed the offense or the crime is actually over 70 years of age, then that also becomes a mitigating circumstance. So the penalty for the crime can be reduced. Okay? Paragraph 3, that the offender had no intention to commit so a wrong as that committed. Okay? So take for example, 'di ba, when going back, the requisites of a crime, of course, or elements of a crime: intent, intelligence, and freedom. So, intent here, you always have to determine in establishing what crime was committed, you always have to establish the criminal intent, okay, or the mens rea. So, it's a principle, the principle of mens rea. So, the intention as an internal act is judged not only by the proportion of the means employed by him to the evil produced by his act, but also by the fact that the blow was or was not aimed at a vital part of the body. Okay? For example, the husband who was quarreling with his wife punched her in the abdomen, causing the rupture of her hypertrophied spleen, from which she died. So here, if you examine, we cannot conclusively conclusively say that by punching a person, we want that person to die. No, here there were no weapons involved actually. So from the circumstances of the crime, we can infer that there was an intent to inflict injury. Okay, the husband wanted to hurt the wife. But it cannot be presumed that the husband wanted to kill the wife. Okay? So most probably in this situation, the intent was to inflict injury, but the result was that it was a grave offense or a graver offense, which was death or the killing of a person. So here, the husband who punched his wife and such punching caused the death of the wife, then the husband, if he is tried in court, can actually raise the mitigating circumstance of what? Of having no intention to commit such a wrong. Okay? So, so here, this is merely a mitigating circumstance because at the end of the day, a crime was still produced. However, even if he can be held liable, the penalty for the husband can be reduced, okay, by virtue of the mitigating circumstance. Number 5, that sufficient provocation or threat on the part of the offended party immediately preceded the acts. That sufficient provocation on the part of the offended party immediately preceded the act. So what are the requisites here? That the provocation must be sufficient. So the offending party, what? started the altercation. He provoked. Okay, the victim here provoked the aggressor. Next, that it must be or it must originate from the offended party. So here, the victim actually started the provocation. Okay? And number three, that the provocation must be immediate to the act. For example, to the commission of the crime by the person who is provoked. Okay? So for example, the victim punched punched the accused in his face. No. But after a few days, but then the victim here punched the accused's face and then immediately ran away. So the accused here, what? Waited for a few days to retaliate. Okay? So he retaliated, but there was a lapse of time no, between the punching. So when he saw the victim again, uh what did he do? He struck him with a bolo. Okay? So or which caused an injury on the part of the victim. So what we have to understand that the provocation in order to be mitigating must be sufficient and immediately preceding the act. So here, the provocation made by the victim a few days before the act or omission was made by the accused can no longer be considered as a mitigating circumstance because there was already material lapse of time. What the law requires is that the provocation, what? Must be sufficient and must have must have been immediately preceding the act. So there should be no material lapse of time. So for example, he was punched on the face. No, for example, A punched B in the face and B retaliated to punch A in the face as well. But when B punched A, he incurred what a cut on his face. So there was an injury. Okay? So the provocation on the part of A because A punched B first. Okay? So B retaliated with a punch but then B sustained a greater injury. So the punching done by A to B can be considered as a mitigating circumstance. But take note, there should be no material lapse of time. So I hope you understand the concept of material lapse of time. Here, the accused should not wait, no, for after a few hours or after a few days to retaliate. His act must immediately happen right after the occurrence of the provocation. Okay? Next, lastly, that the act was committed in immediate vindication of a grave offense to the one committing the felony. His spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, or relatives by affinity within the same degree. So, ini, bumulusla, an accused, no? So what happened here is that there was a grave offense committed against the relatives of the accused, against the spouse, the ascendants, and iya parents, descendants, and iya mga anak, legitimate, natural, or adopted brothers or sisters, or relative by affinity within the same degree. So, ang natabusyahan, ginpasakitan ang iya relative. So him, the accused, because he wanted to vindicate what has happened to the relative, bumulos siya. Okay? But take note that the requisites include that there be a grave offense done to one committing the felony, his spouse, ascendants, descendants, legitimate, natural or adopted brothers or sisters, or relatives by affinity within the same degree. That the felony is committed in vindication of such grave offense, a lapse of time is allowed between the vindication and the doing of the grave offense. So take note of the circumstances for this to be considered as a mitigating circumstance. No, number one, there should be a grave offense committed to the accused, his spouse, his ascendants, descendants, legitimate or natural or adopted brothers or sisters, or relative by affinity within the same degrees. So we go back. What are grave offenses? No, grave felonies are those to which the law attaches capital punishment or penalties which in any of their periods are afflicted in accordance with Article 25. So the first one is that the felony committed against the accused, his spouse, his ascendants, descendants, brothers, or other relatives by affinity in the same degree should be what? Punishable either by capital punishment or death penalty or penalties which in any of their periods are afflictive. So, afflictive penalties include reclusion perpetua, reclusion temporal, prison mayor. So, what is an example of a grave felony? So, rape is a grave felony. Okay? So, for example here, the accused acts in immediate vindication because his wife was raped. Okay? So, ginrape an iya asawa. Bumulos siya didto han nagrape han iya asawa as an immediate vindication. So, Haniya pagbulos, as a result, he killed the rapist. So he took the law into his own hands. No? Ginpatay niya ang nagrape niya asawa. So, is number 5 an available mitigating circumstance for him? Yes, because number 1, there was a grave offense committed against his spouse, sa iya asawa. Kaya ginrape pa niya asawa. Rape is a grave offense. Okay? Number 2, the felony is committed in vindication of such grave offense. So he killed the rapist because he wanted to vindicate. Gusto niya bulson ang natabuhan niya asawa. So that's also present. It was for an immediate vindication. In this case, it doesn't matter whether there is a material lapse of time. It's allowed. Even if after may dana pera ka adlaw or pera ka bulan na tabuan rape han asawa, the husband can still go after the rapist, okay? And inflict injury on him. But however, take note, this is just a mitigating circumstance. This does not what? This does not This does not what? This does not exempt from criminal liability. Okay? So, an immediate vindication because para maging justifying hiya or defense of relatives, what should be the requisites? Okay? Defense of relatives, there be unlawful aggression, reasonable necessity of the means employed to repel it. In case a provocation was given by the person attacked, the one making a defense had no part therein. Okay? So, many and requisites for a valid defense of relative. So, it should be what? It should be immediately after the grave offense committed with the spouse, ascendants, descendant, or legitimate child, or legitimate descendants of the worker of the person defending himself. So here there was an appreciable amount of time, no material lapse of time. So if there's already material lapse of time, it is no longer justifying but merely mitigating. But take note, the offense committed against himself, against the spouse, the ascendants, descendants, legitimate or natural brothers or sisters or relatives by affinity within the same degrees, should be what? Should be punishable either by what? By death, by reclusion perpetua, by reclusion temporal, or prison mayor. So where do you get the punishments? It's actually in book 2. There, when we talk about the crimes already, specific crimes defined under book 2 of the revised penal code, that's where we find the essential requisites for each crime committed. Okay? So I hope that this is already very clear on your part. But anyway, on Monday, I hope we can meet on Monday to get to also have a review, and also so that I will be able to know if you have any questions about the discussion. Okay, so for now, that's it for today. I hope you learned something from my discussion. Please do not ever forget our discussions in justifying, exempting, and mitigating circumstances. We are not done with mitigating circumstances. We still have to discuss paragraph 6 to 10. Okay, by Monday. So hopefully by then we will be able to meet. The weather will have cleared up. So you will have a better connection so that you can understand the concepts better when it comes to these types of circumstances. So what is the effect of mitigating circumstances? If there are several mitigating circumstances, the penalties that may be applied to for the commission of the crime can be reduced. Okay, so we will discuss how these penalties are actually reduced by by appreciating mitigating circumstances. Okay, so anyway, thank you so much everyone for listening to my discussion. So I have a question. Okay, on the last part of our video, I will interpose a question. So I will be sending a Google form after after this, and I hope that you will be able to post the question so that I will also know that you are watching the video presentations that I am making. So I really am taking the time to study and also to make the video presentations for you guys. I've considered just posting it on YouTube so that you can review actually using the videos, as well as so that you will not have any difficulties connecting in Zoom, because I noticed that some of you are having problems understanding the concept because apparently some of the discussions are not relayed to you because of the difficulties in the internet connection. So in YouTube, you can access the video presentations anytime. So anyway, now I will be giving you well, I will be giving you my question. My question would be is that what are the nine the nine justifying or mitigating circumstances that can be considered for what? Oh, sorry. What are the nine justifying and exempting circumstances that can be considered for mitigating circumstances if the requisites of this justifying and exempting circumstances are not all present. So if you watch this video until the very end, you will be able to answer my question. So here are the nine justifying and mitigating circumstances which can still be considered justifying and exempting circumstances which can still be considered as mitigating circumstances in the event that the requisites for a complete justifying and exempting circumstance are not present. Okay? Number one is self-defense, defense of relatives, defense of stranger, state of necessity, performance of duty, obedience to order of superior, minority over 9 and under 15 years of age, causing injury by mere accident, and controllable fear. So these are part of our justifying and exempting circumstances. But if the requisites of self-defense, defense of relatives, defense of stranger, state of necessity, performance of duty, obedience to order of superior, minority over 9 and under 15 years. No, this one is already minority over 15 years of age but less than 9. Okay, I have to edit this one. 15 but under 18. This has already been amended, as I've mentioned several times. Minority over 15 and under 18 years of age, cause if what? If may ada discernment, if a discernment is established, then this one becomes a mitigating circumstance. Okay, so these are included in paragraph 1 of mitigating circumstances. Those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attended or not present. So okay, that's all for today, class. I hope you understood the concept. But anyway, just ask me a question if there are certain concepts that are unclear to you or that are difficult to understand. We will discuss them thoroughly once we meet again on Zoom. Okay, so anyway, thank you so much everyone for taking my class. I'll just see you again next time. I will make the proper announcement if we can already meet in Zoom. Okay? Thank you and good afternoon.